Evaluation of contract law. The benefits of contract law are that it promotes certainty, protects reasonable expectations, and supports commercial reliability, whereas the drawbacks are that it can be rigid, complex, and sometimes produce unfair outcomes. Formation of a contract. The formation of a contract is the legal process where a binding agreement is created between parties and includes offer and acceptance, intention to create legal relations, and consideration. Offer and acceptance. Offer and acceptance is the process where one party makes a clear and definite offer that is accepted unconditionally by another party, creating agreement. The benefits of the law on offer and acceptance are that it provides certainty, uses clear objective tests, and distinguishes clearly between offers and invitations to treat. The benefit that it provides certainty is that clear rules about communication and acceptance allow parties to know when they are legally bound, as shown in Intours Limited v. Miles Far East Corporation. The benefit that it uses an objective approach is that agreements are judged by outward conduct rather than hidden intention, promoting fairness and predictability, as shown in Smith v. Hughes. The benefit that it distinguishes offers from invitations to treat is that it protects sellers from being bound too easily in retail situations, as shown in Pharmaceutical Society of Great Britain v. Boots Cash Chemists. The drawbacks of the law on offer and acceptance are that some rules are outdated, communication rules can be artificial, and distinctions can be overly technical. The drawback that some rules are outdated is that the postal rule can create unfairness by binding an offer before acceptance is received, as shown in Adams v. Linsell. The drawback that communication rules can be artificial is that silence cannot amount to acceptance even where it may reflect genuine agreement, as shown in Feldhaus v. Binderley. The drawback that distinctions can be overly technical is that complex analysis of counter-offers can defeat genuine agreement, as shown in Hyde v. Wrench. The possible reforms for offer and acceptance are to abolish the postal rule, codify the rules in statute, and introduce greater flexibility for electronic communications. The reform of abolishing the postal rule would increase fairness and align the law with modern communication methods, but it may reduce certainty for offerees who rely on posting acceptance. The reform of codifying the rules in statute would improve accessibility and clarity, but it may reduce judicial flexibility and the ability to adapt to new situations. The reform of introducing clearer rules for electronic communication would modernize the law and reflect commercial practice, but it may create complexity where different technologies require different treatment. Intention to create legal relations. Intention to create legal relations is the requirement that parties must intend their agreement to be legally binding before a contract is formed. The benefits of the law on intention to create legal relations are that it prevents trivial claims, reflects social reality, and promotes commercial certainty. The benefit that it prevents trivial claims is that domestic arrangements are presumed not to be legally binding, reducing unnecessary litigation, as shown in Balfour v. Balfour. The benefit that it reflects social reality is that social agreements are treated differently from business agreements, preserving personal relationships, as shown in Jones v. Padavatten. The benefit that it promotes commercial certainty is that business agreements are presumed to be binding, supporting trade and economic stability, as shown in Edwards v. Skyways Limited. The drawbacks of the law on intention to create legal relations are that presumptions can be artificial, outcomes can be unpredictable, and some deserving parties may be denied remedies. The drawback that presumptions can be artificial is that domestic agreements may be legally binding where relationships have broken down, creating inconsistency, as shown in Merritt v. Merritt. The drawback that outcomes can be unpredictable is that determining intention can depend heavily on specific facts, leading to uncertainty, as shown in Simpkins v. Pays. The drawback that deserving parties may be denied remedies is that reliance on informal promises may not be protected where intention is not proven, as shown in Balfour v. Balfour. The possible reforms for intention to create legal relations are to abolish presumptions, codify the doctrine, and replace it with a reliance-based test. The reform of abolishing presumptions would allow courts to focus entirely on the facts of each case, but it may reduce certainty and increase litigation. The reform of codifying the doctrine would improve clarity and accessibility, but it risks oversimplifying a nuanced area of law. The reform of replacing the doctrine with a reliance-based test would protect parties who act on promises, but it may undermine freedom of contract and expand liability excessively. Consideration. Consideration is the requirement that each party must provide something of value in exchange for a promise for a contract to be enforceable. The benefits of the law on consideration are that it distinguishes enforceable agreements from gifts, supports reciprocity, and promotes certainty. The benefit that it distinguishes enforceable agreements from gifts is that only bargains are legally binding, preventing excessive claims, as shown in Curry v. Misa. The benefit that it supports reciprocity is that both parties must provide value, ensuring fairness in exchange, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. The benefit that it promotes certainty is that the rule against past consideration clarifies when obligations arise, as shown in Ream Cardle. The drawbacks of the law on consideration are that it can be technical, inflexible, and sometimes unjust in commercial practice. The drawback that it is technical is that performing an existing duty may not amount to good consideration, producing artificial distinctions, as shown in Stilk v. Myrick. The drawback that it is inflexible is that part payment of a debt is not good consideration for the whole, even where agreed, as shown in Folks v. Beer. The drawback that it can be unjust in commercial practice is that practical benefits are sometimes recognized inconsistently, creating uncertainty, as shown in Williams v. Roffey Brothers and Nichols Limited. The possible reforms for consideration are to abolish the doctrine, to expand the doctrine of promissory estoppel, and to recognize practical benefit more consistently. The reform of abolishing the doctrine would simplify contract formation and align English law with other jurisdictions, but it may remove an important filter distinguishing serious agreements from casual promises. The reform of expanding promissory estoppel would promote fairness and protect reliance, but it may undermine certainty and blur the boundaries of enforceability. The reform of recognizing practical benefit more consistently would reflect commercial reality and reduce technical disputes, but it may weaken the requirement for genuine exchange and increase opportunistic claims. Terms of a contract. The terms of a contract are the specific promises and obligations that form the content of the agreement and include express terms and implied terms. Privity of contract. Privity of contract is the rule that only parties to a contract can sue or be sued on it. The benefits of the law on privity of contract are that it protects party autonomy, prevents excessive litigation, and promotes certainty. The benefit that it protects party autonomy is that only those who agreed to the contract are bound by it, preserving freedom of contract, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. The benefit that it prevents excessive litigation is that third parties cannot interfere in private agreements, reducing unnecessary claims, as shown in Tweddle v. Atkinson. The benefit that it promotes certainty is that contractual liability is clearly limited to identifiable parties, supporting commercial predictability, as shown in Bezic v. Bezic. The drawbacks of the law on privity of contract are that it can cause injustice to third parties, undermine commercial intentions, and require artificial legal devices to avoid unfairness. The drawback that it can cause injustice is that a third party who was intended to benefit may be unable to enforce the contract, as shown in Tweddle v. Atkinson. The drawback that it can undermine commercial intentions is that parties may clearly intend to benefit a third party but the law may not give effect to that intention, as shown in Bezic v. Bezic. The drawback that it requires artificial devices is that courts have relied on trusts or agency to avoid harsh outcomes, complicating the law, as shown in Jackson v. Horizon Holidays Limited. The possible reforms for privity of contract are to expand statutory rights for third parties, abolish the doctrine entirely, and clarify the scope of third-party enforcement. The reform of expanding statutory rights for third parties would improve fairness and reflect commercial practice, but it may increase litigation and reduce certainty for contracting parties. The reform of abolishing the doctrine entirely would align the law with modern expectations and simplify enforcement, but it could undermine party autonomy and expose parties to unexpected liability. The reform of clarifying the scope of third-party enforcement would improve certainty and accessibility, but it may limit judicial flexibility in achieving just outcomes. Incorporation of terms. Incorporation of terms is the process by which contractual terms become binding through signature, reasonable notice, or previous course of dealing. The benefits of the law on incorporation of terms are that it promotes certainty, encourages clarity in drafting, and protects parties through notice requirements. The benefit that it promotes certainty is that a signed document will normally bind the parties regardless of whether it was read, as shown in Lestrange v. Graucob. The benefit that it encourages clarity in drafting is that terms must be clearly presented to be effective, incentivizing transparency, as shown in Thornton v. Shoe Lane Parking Limited. The benefit that it protects parties through notice requirements is that unusual or onerous terms must be brought to attention, promoting fairness, as shown in Interphoto Picture Library Limited v Stiletto Visual Programs Limited. The drawbacks of the law on incorporation of terms are that it can be harsh, overly technical, and dependent on fine factual distinctions. The drawback that it can be harsh is that a person may be bound by unfair terms simply by signing a document, as shown in Lestrange v Graucob. The drawback that it is overly technical is that small differences in timing can determine whether terms are incorporated, as shown in Ollie v Marlborough Court Limited. The drawback that it depends on fine distinctions is that previous dealings must be regular and consistent, creating uncertainty, as shown in McCutcheon v David McBrain Limited. The possible reforms for incorporation of terms are to strengthen statutory control, require clearer consent to onerous terms, and codify the rules. The reform of strengthening statutory control would enhance consumer protection, but it may increase costs for businesses and reduce freedom of contract. The reform of requiring clearer consent to onerous terms would promote genuine agreement, but it may create practical difficulties in fast-moving commercial contexts. The reform of codifying the rules would improve accessibility and consistency, but it may reduce flexibility in responding to new commercial practices. Classification of terms. Classification of terms is the process of categorizing contractual terms as conditions, warranties, or innominate terms to determine the appropriate remedy. The benefits of the law on classification of terms are that it provides structured remedies, allows flexibility, and promotes fairness. The benefit that it provides structured remedies is that breach of a condition allows termination and damages, creating clear consequences, as shown in Poussard v Spires. The benefit that it allows flexibility is that innominate terms enable courts to assess the seriousness of breach, as shown in Hong Kong Fur Shipping Co. Limited v Kawasaki Kisen Kaisha Limited. The benefit that it promotes fairness is that minor breaches of warranties do not justify termination, preventing disproportionate outcomes, as shown in Bettini v Jai. The drawbacks of the law on classification of terms are that it can create uncertainty, encourage litigation, and involve complex judicial interpretation. The drawback that it creates uncertainty is that it may be unclear whether a term is a condition or innominate term until litigation occurs, as shown in Hong Kong Fur Shipping Co. Limited v Kawasaki Kisen Kaisha Limited. The drawback that it encourages litigation is that parties may dispute the seriousness of breach to determine remedies, as shown in the Mihalis Angelos. The drawback that it involves complex interpretation is that courts must analyze the effects of breach in detail, increasing cost and delay, as shown in Sahave NVV Bremer Handelsgesellschaft MBH. The possible reforms for classification of terms are to adopt a unified seriousness of breach test, codify categories in statute, and expand the use of innominate terms. The reform of adopting a unified seriousness of breach test would increase flexibility and fairness, but it may reduce certainty at the time of contracting. The reform of codifying categories in statute would improve clarity and consistency, but it may create rigidity and limit judicial discretion. The reform of expanding the use of innominate terms would reflect commercial reality, but it may increase uncertainty and litigation over consequences. Exclusion clauses. Exclusion clauses are contractual terms that seek to limit or exclude liability for breach of contract or negligence. The benefits of the law on exclusion clauses are that it respects freedom of contract, enables risk allocation, and supports commercial certainty. The benefit that it respects freedom of contract is that parties can allocate risk as they see fit, particularly in commercial agreements, as shown in Photo Production Limited v Securica Transport Limited. The benefit that it enables risk allocation is that businesses can control potential liability and price services accordingly, as shown in Elsa Craig Fishing Co. Limited v Malvern Fishing Co. Limited. The benefit that it supports commercial certainty is that clearly drafted clauses will generally be upheld, providing predictability, as shown in Lestrange v Graucob. The drawbacks of the law on exclusion clauses are that they can be unfair, rely on technical interpretation, and disadvantage weaker parties. The drawback that they can be unfair is that powerful parties may exclude liability for serious breaches, as shown in Photo Production Limited v Securica Transport Limited. The drawback that they rely on technical interpretation is that courts may interpret clauses strictly against the party relying on them, creating unpredictability, as shown in Hollier v Rambler Motors Limited. The drawback that they disadvantage weaker parties is that consumers may agree to broad exclusions without real bargaining power, as shown in Thornton v Shoe Lane Parking Limited. The possible reforms for exclusion clauses are to strengthen statutory reasonableness tests, prohibit certain exclusions entirely, and require clearer drafting standards. The reform of strengthening statutory reasonableness tests would enhance fairness and consumer protection, but it may increase compliance costs and reduce commercial flexibility. The reform of prohibiting certain exclusions entirely would prevent serious injustice, but it may restrict legitimate risk management in commercial contracts. The reform of requiring clearer drafting standards would promote transparency and informed consent, but it may increase formality and complexity in contractual documentation. Thank you for watching this video on evaluation of contract law. I'll see you in the next one.